case D516583, Crane versus Sevilla, set today for return from the drug test and the warrant status relative to the plaintiff. And there was, after the last hearing, Mom had a right to and did file her reply to Dad's opposition and counter motion. Let the record reflect. Oh, counsel, kindly your appearance for the record.
Robert Glennon, bar number 2143 for plaintiff in an unbundled capacity.
Good morning. I haven't seen you in a long time.
No, not on purpose.
And Brandy, you are defendant. You are Mom representing yourself, correct?
Correct.
Welcome. Okay, Dad's traffic warrant was cleared up, so he doesn't have that happening anymore, but he's presumed positive. He went to the options and did not drop a sample until the following day. And the following day he hasn't even paid for that. So my policy for 12 and a half years is that he's going to have to complete 12 consecutive weeks of clean patches, and after that he can either re-petition the court for unsupervised visits, or Mom can come to an agreement. I can give them a mediation order. These are the things that need to be stated before argument, is what I'm going over this stuff. Mom attached a picture, apparently, of Dad's penis while he was next to a child, allegedly. So I have to strike the last page of Mom's Exhibit 1 to her reply that was filed on August 24th, 2015. If there is an evidentiary hearing in the future, you're not barred from presenting it in that matter, but you can't really file it in the court papers because it's basically pornography.
Oh.
So that also, with all that Mom filed in her reply, if Dad cannot prove that he's taken at least a 28-week domestic violence intervention class through any criminal case, then I'm going to be ordering that he also do the 28-week options domestic violence. It's a group. It's not anger management. It's a group setting where the people can discuss their issues and confront each other. And I don't find adequate cause for an evidentiary hearing in this matter when Dad's presumed positive. I got the letter from ATI, which has been provided. I don't know if you have a copy of that, Bob. Did you read that?
Yes, Your Honor.
I get about one of those per year, and they're usually when someone is trying to hide something. Not assuming, I'm just telling you what my orders always are when someone doesn't do it timely. Let me see, I have one more thought here.
And if we could deal with that, Your Honor, would Your Honor consider the test results if they come back?
Nope. Never will, never will. Mom alleges several TPO violations, and the court would just have, look, the law allows you, when someone's violating a TPO, to file a motion for contempt, and it's called an order to show cause motion, and you can file it in the TPO court, or you can file it in this court. Usually they have to have an evidentiary hearing. They're usually very short, but you can't complain about something like that and never seek a remedy. If you feel he's violating it and the kinds of things that you wrote to me look like he is, those allegations, if they're true, those would be violations. And I believe if he's continually violating it or more recent than obviously when you got the TPO, you also are allowed to ask for an extension at the same time. So what I want from Dad is him to file proof of 12 consecutive clean option patches and complete the 28-week domestic violence course. And then I can give the parties something to mediate, which may not be good because of the domestic violence allegations. And they give an assessment now down there. And if they think that there's a problem, they're going to kick it back to me anyway and say, we're not going to do this due to the DV between the parties. Or he can repetition the court. In the meantime, I was considering either a Donna's house order, or these are the three options we have unless counsel or Mom can think of something else. Donna's house order to have visitation with Autumn in the meantime, or Mom at her discretion. She can't be the supervisor, but she could allow supervised with someone the parties both trust. That's kind of where I am with this case, and I'm willing to listen to argument. Bob, you can go first. Mom can go second. Unless you guys are okay with those orders.
Your Honor, in Cedric Kern's courtroom in Las Vegas Municipal Court in 2013, Mr. Crane completed a 26-week domestic violence course as part of...
he's had a TPO since then. So if he's done it since then he doesn't have to. If he hasn't and he's still continuing with this kind of behavior, then he's going to take it again because he didn't learn what he needs to learn.
I mean, obviously the reason for an evidentiary hearing is to see if there's the behavior's continuing or the rewards the mom is continuing.
Agreed. After he has proven he's clean, I'm happy to have an evidentiary hearing. When you have someone who's presumed positive for drugs plus domestic violence currently pending, I do not have a cause for an evidentiary hearing. We have 40,000 cases each. There's no way I'm going to be held responsible under Rooney to hold an evidentiary hearing when someone is presumed positive for drugs and has a current TPO with allegations of current violations. I'm telling Mom she can either file a motion here or in the other court. I can't really go forward on these allegations without someone requesting, relief relative to that. But in the meantime, if someone's presumed positive, they have supervised visits, and that's it. So
Regarding supervised visits, the reason he's presumed positive is he didn't have the money to pay for the test. Donna's house is not cheap, although, it's reasonable. It's still money.
They told him in the letter, if you read it, and it's always been the policy of ATI, if you drop your sample timely, you can come back and pay for it any time before the following hearing. The following hearing date is always on the paperwork, and people who want to prove they're clean have no problem taking that test. So Dad was there. He even apparently tried to get the ATI lab worker or the reception person to believe that he had somebody else in the lobby when they gave him back the paperwork so he could call the court, and then later found it on his own person. I mean, Mom also listed all these reasons why she thinks he's not credible. All I care about is him being clean and him understanding what acts of power and control and domestic violence are and learning other ways of handling his impulse control problems. I mean, when you were not here, I went over his history in the criminal system, which is, it's not something that can be ignored. I know he got upset about that, but I mean, he's got a criminal history, over 25 traffic in the last 15 years. The warrant, he took care of it. I'm happy with that. In 2002, I think it looks like a drug-seeking theft crime. He went to drug court for petty larceny and grand larceny, and then he had battery DV, 2002, DUI, 2006, and violating restraining order, 2013, and 2013 battery DV. So I do not think I have cause for an evidentiary hearing until Dad proves he's clean.
Okay.
And that he's taken the DV intervention class.
And I'm not looking to argue with Your Honor. It was my understanding that he did drop a sample the next morning.
No. Read the letter. He dropped,
I did,
he dropped
though.
it the next day, not the day. I have a time that says he has to do it by on that order. It specifically gave him a time. And I follow that because otherwise people can use adulterants, shave their body hair, and do other things. I mean, I did the criminal drug court for 2 years. So for me, this is a serious thing, and I've never had a different order, and it always works when someone wants to prove they're clean.
Okay, so he did drop the next day, so it doesn't count.
So he's presumed positive.
Gotcha.
Yeah.
With regarding
that
visits,
goes out of your system very quickly. So if people are, using that, that's something that you have to test for very often because it's not something that stays into your system. So I don't know what it is that he's possibly using, but he's presumed positive. Does he want to use Donna's house? Donna's house does cost $10 or $20 an hour, and they're open Wednesday, Thursday, Friday between 6 p.m. and 8 p.m. And every weekend they're open all day from 9 a.m. to 6 p.m. They've never let me give more than, I've attempted in the past to give 3 and 4 hours at a time, but I've given 2 hours at a time and they haven't kicked it back. But if they don't have time, they will reduce it to to a 1 hour that works for both parties. If they can't, accommodate all of the supervised visitation orders that are being sent down there, and I have no idea how busy they are.
and what we had preferred was Mr. Crane's parents, who just finished a stint supervising visitation in Judge Duckworth's court. But if both parties have to agree, I guess we have to see if we can reach an agreement.
Mom, who, do you have anybody you can suggest? And what about Dad's parents? And if not, why not?
The Donna's house sounds great right now. I do not suggest his parents in regards to the supervised visitation they had with our nephew, Rage Crane, and the problems that they caused with that and our daycare at that time. So
I need more
uh,
details, not just an allegation.
details. During supervised visitation, this is referencing to case D14-506229C regarding Brian Crane and Christy Crane. The minor child was Rage Wesley Crane, which is my nephew and the plaintiff's nephew. They had supervised visitation, and during that time, the mother created a fraudulent GoFundMe, or a committed charitable fund fraud, and she created a fraudulent GoFundMe account claiming child abuse, opened up CPS files on my nephew, claiming abuse with the mother, which is my girlfriend, and also my daycare provider. So my daycare provider actually had to go and testify in that child custody case last year to prove that all the allegations were false. CPS was closed, and that's why I do not recommend his parents to be supervised, to do the supervised visitations, as I do not trust them.
But what did they do? What did they do that makes you not trust them? I thought you said
Threats.
his maid did that.
His mother has actually she's threatened me at my job. She's done fraudulent.
In what way?
She's submitted emails to my job stating that I'm giving away customer information. I work for a check cashing company, and I work in the legal department, and she posed to be another person. She sent it from her email, however, and that's how we knew it was her, claiming that I was giving away information and that I should be fired, and my company can provide that email upon court's request. She's called into my job claiming to talk to me during a time where the restraining order was in effect, and that restraining order protects me from third-party harassment, and that includes his family. So she was trying to get me fired out of retaliation for getting a restraining order against her son. His father that sits behind him today has actually arrived at my job. That was on June 18th, I believe. And he and his girlfriend, the plaintiff's girlfriend, I believe is his girlfriend, is the meth addict that I was speaking of earlier. She and him chased me down in my parking lot. There are about 13 witnesses at my job who saw it, and also video surveillance, which I do have in my bag.
You wrote about that.
Yes. So that's why I do not trust them. I do not believe that they have the best interest of our child in mind. And if we can do supervised visitations in the beginning, I would like to do that just for a short period of time. If he can prove that he's clean for those 12 weeks, and do that another intervention class for domestic violence, because apparently the first one didn't work.
That's why we need an evidentiary hearing, to see if the first one worked, or to see if this is being created.
It didn't work, and that's why I had filed the other restraining orders, and there was other violence that happened after that. So
Keep hearing about witnesses.
He has a TPO. It's in effect till March of 2014, and that is after he took the 2013 class. So he obviously has a problem. Plus, there was a violation of TPO or a protection order in 2013, a separate case. So he definitely needs to learn some different skills, how to handle anger, frustration, impulse control issues, and power and control issues. And I like the DV program at Options because it's not an anger management class where you sit and listen to information. It's a class that they get down to the emotional level in a group, where they're each confronting each other about behaviors and understanding different ways to handle things, and helping each other see their part in the problem. So it's more of a therapeutic rather than an educational kind of an intervention. And, I'll certify the question for appeal. If the Supreme Court says I need to have an evidentiary hearing when I've got all that in front of me before I require that he finish his drug 12 consecutive patches and take a DV intervention class, then if they can't come to an agreement, I'm happy to have an evidentiary hearing. But I'm not going to have one when I've got that kind of stuff going on. We have too many cases. And he first needs to prove that he's clean, and he needs to prove that he has done what I'm asking him to do regarding domestic violence. To me, I don't have to say she's right about these violations. I'm telling her she needs to take care of that if she thinks that's what's going on. But there's no doubt that I can take judicial notice of the fact that these things that have occurred relative to violence are since he took that class, because they're after the date that you said he completed it. So,
Your Honor.
I'm happy. What I'm hearing Mom say, and let me see what you think about this on behalf of your client. If they build some trust, and Dad does these visitations at Donna's house for a while. She sounds like she's willing to drop that after a period of time and set it up so that his parents can watch him.
I would rather Stephanie be the one who monitors, which is kind of like his sister-in-law. I trust her over his parents.
Is that someone who'd be willing to do it, Dad?
I don't know. As far as I know, they're moving to Salt Lake City, Utah.
Pardon you, as far as you know what?
They're moving to Salt Lake City, Utah.
So that wouldn't work. If his parents are willing to sign a supervision agreement where they'll maintain line of sight and there won't be harassment, you know, those kinds of things.
Well, they're part of the harassment, Your Honor, and that's why we have I have no contact with his parents whatsoever due to that.
You can't say it.
Or you have a stalking and harassment from...
Just the evidence that I've gathered from his mother and everything else. I have it all in my folder.
You
but
said it as if you have an order to stay away.
there's no order. I'm sorry if I confused you. It's just.
Would you be
based upon-
willing to draft something for the plaintiff once they do maybe a month or two of Donna's house and get something between them for supervised outside of Donna's house? It's actually better for the child, Mom, because it is an institutionalized setting. They have games and things you can do. You cannot eat in there. There are other people doing it at the same time. They are watching everybody, obviously, but it's much nicer to build and maintain a relationship when you have other significant others around that are not, abusive, neglectful, that will create a good environment for the child where you could eat together and do things that are more.
I would feel most comfortable with that after he's proven that he's clean.
So how many weeks do you want to see clean? He still has to finish 12 for me, but how many weeks do you want to see clean before you would allow him to have supervised by a relative?
Would it be okay if, well, let's see, today is it's August.
27.
If we could do those 12 weeks so that by the time of Christmas comes around, he might be able to spend Christmas with our daughter. That's 12 weeks, correct?
It's a 12-week consecutive order. I thought you were saying if he stays clean for a while, meaning less than 12 weeks, you would be willing. He still has to do the 12 weeks.
Okay.
But if he was staying clean for a significant number of weeks during his wearing of the patch, that you would switch to a relative supervising versus having to go down to Donna's house. I just want you to remember your child is also going to be going there. And Mr. Glennon could prepare an order regarding, if it's his parents, regarding, no harassment, find a way to do a neutral exchange to minimize,
Conflict.
Yeah,
I
conflict.
would like that. Yes. What do you think about, is 8 weeks?
How about 6 weeks?
6 weeks is good.
And after he's clean for 6 weeks. But Dad, after that, if you have a dirty patch, and remember, if it's tampered with or it's taken off, it's presumed positive and you have to start over again.
I don't do drugs, Your Honor.
Okay, I hope that's true, and
The only reason that it didn't get paid for because it was $130 and I was never told that it costed any money. They made it seem like I couldn't even take the test.
She
No,
wrote
they
it
didn't.
down.
The only thing that I was told when I walked in there was that they wouldn't even let me test for $130 unless I had $130.
That's not true, Dad, because I have so many cases where we get the form from them that says it's on hold. And then sometimes people pay right before they get to court. Great, I know whether they're clean or dirty. Many times they don't, and they're presumed dirty.
That's
You
fine.
took it the following day. I don't take it after the time that I state that you have to be there.
I understand.
And you have to have the 12 consecutive clean patches. If you're not dirty, you're not going to have to worry about it.
I'm not worried about it. It's my whole history is I don't understand why the plaintiff's not being drug tested as well because I have the proof and text message that we were doing drugs together during our entire relationship. That we were smoking pot together.
That is not true.
I can show it in text message if needs be.
That's fine. I'm willing to do a drug test, and that's perfectly fine because I do not do drugs.
Well, I don't have a problem ordering that you do a drug test.
But I
But
won't
if
be
it
able
comes
to.
back clean, he's going to reimburse you the $126. And I'm not going to have a return date on it. Both sides will have to call and request to come down and see them, or if Bob calls from his office and we can tell that it's the lawyer's office representing Dad, we can give him over the phone, but we can't give him to you over the phone because we don't know if it's you. So you have to come down and look at them.
That seems fair, Your Honor.
All right, so in the meantime, for the first 6 weeks, what hours work for both of you? Because you're going to be dropping the child and then picking the child up from supervised visits, and Dad needs to do it when he's also available and not working.
I work Monday through Friday, 8 to 5. When I get off, I have to pick up our daughter from daycare by 6 p.m. And I usually pick her up by 5:30. And I live clear across town out by Blue Diamond. So,
Well, he could do either Wednesday, Thursday, Friday, 7 to 8, or he can do, I could give him at least a 2-hour block on weekly on either a Saturday or Sunday. Why don't you guys talk about that while I fill out this drug test order?
Stanley,
On visits.
when are your days off?
I don't know my days off.
Oh, when are his days off?
I don't know my days off. We just
He
lost
gets
6
different ones.
employees. I have different days off every day of the week.
You've had some contingency on Wednesday. Do you want to?
Yeah, Wednesdays are fine.
Now,
It'd be like a Wednesday
working
and Saturday.
the evenings as opposed to days, right?
Yeah.
My days off are Saturday, Sunday, so those would be best for me to come down, since it'll be about a 45-minute drive for me. And 7 to 8 o'clock that's her bedtime. That's her shower time and dinner and bedtime for her. Perhaps do it maybe from, if I get off of work, I pick her up by 5:30. I could probably be here in about by like 6:15, maybe from 6:30 to 7:30 to alleviate some of the stress on Autumn.
Donna's house closes at 6
If they
p.m.
let you do that, that's okay, but I'm only given I can only circle what they say they're available for, and they have it set up so they're dealing with a lot of people. I doubt that they want to do something on the half hour, because they're not offering that on the half hour.
And maybe the weekends. If it's just for a couple of hours.
You could do any time for 2 hours between 9 and 6. Don't choose an eating time, because they can't eat unless you're going to feed them right before they come. Or feed Autumn right before she comes.
Our worry is he right now has different days off depending on his shift, and we got to choose one.
So there's no consistency.
Saturday or Sunday.
Is he
We just
always-
lost 6 employees, so I've worked every day through from around the clock. I'll work a day shift, and then I'll end up going back for a graveyard shift because we don't have an employee to cover that shift. So I'm the only one that's to cover those shifts.
Wow. Okay, let me ask you this, Dad. Are you always available on a weeknight between 7 and 8, no matter what?
Yes.
So let's just do that. And you guys can ask Donna's house, and I'll write a little note here. Parties would like it to start at 6:30, so that you could have till 6:30 to 8. If they allow you to do that, I have no problem with it. I just don't want to presume they're going to do it. They are willing to work with people. I just don't know about that issue. No one's ever asked me to do it on the half hour. How does that sound?
What days would this be on?
They're only open Wednesday, Thursday, Friday.
I do have my 13-year-old at home that needs help with homework, and I have to get dinner ready, so that's 3 days is a little excessive.
No, I'm saying those are the days they're open.
Oh, okay.
I'm not saying go 3 times a week. I mean, I think is there any activity your older child has on Wednesday, Thursday, or Friday?
No extracurricular at this time. She just started.
What does your client want to do?
Is Your Honor thinking 2 hours a week?
Well, I'm trying to.
Thursday,
I'm writing
Friday?
here 6:30, and then parties would like to start at 6:30 to 8, if possible, because I don't think she can really get there earlier than that if she gets off at 5:30, like for sure. And if you're late, I know that I don't think that they like if you're late. I'm not sure how they handle that.
And I guess I'm asking Your Honor, it's going to order, hey, one of these 3 days, or 2 of these 3 days, or 2 hours total in a week?
I think two days a week if he can be consistent, but if he misses two of these visits, then reduce it to 1 so that he can prioritize.
All right. What do you think?
Do you think you can?
Fine.
Can we do one?
I can work 2 days a week. I can do it
We can do it. We can do 2 days
What
a week.
about Wednesday and Friday, Mom?
Okay.
Okay, so Wednesdays and Fridays, I'm asking for 6:30 to 8. And if they can't do it, I'll just give 7 to 8 p.m. But I think that they will have some sympathy and hopefully be able to do that. And I put it'll be until further notice, and that there's not a return date. And what I would like you to do, once Dad's clean, Mom, and he proves he's clean, he says he's clean now. Once he's got the proof that he's clean and the DV intervention has been completed, then I want you guys to talk about what you can do for visitation. If the TPO is still in effect, you may have to make a motion before the court unless Mr. Glennon is on the case. Then you could talk to him about your thoughts, and Dad could talk to him, and maybe Bob can draft something up. Would you be on the case, you think?
Yes.
That would work, and then you don't have to be in the same room, and you could talk to him by phone. You want to try that? Once Dad's clean, and shows he's clean, and he's done with the DV intervention.
To come up with a mediation with the attorney?
Come up with a schedule that doesn't require supervision, and that can be a schedule that you guys can follow. If his hours continually change, the schedule has to have some kind of a notice period. Like, uploading and emailing a schedule whenever, like if you get it every week or every 2 weeks, so that you guys can then by email co-parent and determine what days he's going to have the child, spend time with the child, if that's changing all the time. The best thing to do is, once they know you're seeing a child on a regular basis, is to get a regular schedule so that you can, be consistent.
Yes, ma'am.
If you can't get that, it sounds like you're in an overwhelming situation right now with regards
People just keep quitting. That's all. So
that's a lot better than people coming in and saying, I can't get a job to save my life. When it rains, it pours, it sounds like. So, do you understand what I'm saying, Mom? When he's done and he's proven he's done, and he'll get certificates from the DV intervention, and he'll get proof in a letter form that'll come to court relative to the patch.
So that'll be so within about 28 weeks I should expect contact from his counsel? Or, does that sound right?
Maybe a little before if he's doing
For
well.
unsupervised
Yeah, I thought we were
visitation?
looking at maybe 6 weeks if the patch.
In 6 weeks, we're looking at finding a relative to supervise. But unless they agree otherwise, he needs to finish those things, and then he can have unsupervised. Sorry.
Right. That's
All
right.
right. So again, I just want to make it clear for the record, we're striking the last page of Exhibit 1 to Mom's reply, and it's not barred from an evidentiary hearing if we have one in the future, which I'm hoping is not going to be needed, because if Dad proves those things, Mom, even if you guys don't get along, you're going to be in the business of raising Autumn together. The child's only 1.5 years old, and it's a long-term thing, and it really doesn't end when they're 18. So you're going to need to come up with something that works, and if Dad is not a danger and Dad is not using drugs and impaired, in any way, then there's no reason why he can't have unsupervised. It doesn't need to be you guys coming into contact. There can always be either a neutral location. There are videos out front of this building if you had to do that, or at the Marshall station. You can do your exchanges at school when she goes to school later on, where you don't come in contact with each other. Or like a Burger King, police substations have videos. There's all kinds of ways to do that stuff where you're feeling safe.
Yes, and my concern right now, and I understand that, and that is
And he feels safe from
ultimately
having
what I want.
allegations. What?
That is ultimately what I would like. However, I just want to make sure that our daughter is safe in his care. I mean, those photos alone are it hurts to even see them. That shouldn't have been done.
You said that the child was right next to him, but I can't tell that from
Yes, she's
looking at
laying
the
on his
picture.
chest.
And if that's true, Dad, it's very inappropriate. And
I understand.
I don't know if that's what it shows because it's black and white and blurry. But if she brings it to an evidentiary hearing, it would need to be the actual photograph. And that would be very inappropriate behavior in the presence of a child. All right. So I need an order from today's hearing. Do you mind doing one? Are you unbundled? Kind of story.
Yes.
You are?
If we need to be clear, then I guess it's on me. I can get the minutes and do the order based on that. It's standard. I guess I got to do it.
If you don't want to, I can have my department do it. Cut and paste the minutes and do an order. It's not a problem.
We can probably get it done quicker. So we'll go on the line here.
All right, thank you. And Mom has the right to review and sign off. If you when you send it to her, send a transmittal letter with it, so that you know what date you sent it, and we'll give 3 days for mailing and 10 judicial days. So basically, a little longer than 2 weeks for her to take a look at that and sign off. If she has not signed off, I will sign it if it matches the minutes.
Thank you, Your Honor.
All right? Have a good afternoon, you guys.